Are you ready to make the most of your oil and gas mineral rights? Welcome to the Mineral Rights Podcast. Get the knowledge and resources you need to manage your minerals and royalties. Here is your host, Matt Sands.
Hello and welcome to the Mineral Rights Podcast. I'm your host, Matt Sands, and I'm joined by my co-host, Justin Williams, and we're here to help you make the most of your minerals and royalties. In this episode, we're going to talk about stipulations of interest and cross-conveyance documents. And Justin, I know that you're familiar with these from your minerals.
Yeah, you said it, Matt. These are really common, I would say, in different situations, and especially when you have, a ton of mineral owners in a tract, and you have fractionization of these interests. Questions come up, whether it be, is something included or who owns exactly how much. There's a lot of questions that can come up.
Yeah, exactly. So we're going to answer some of those questions as to when these types of instruments are used, when you might encounter them, why you're being asked to sign them. Oftentimes, you'll be approached by an oil and gas company when you're, typically when they're looking to pay royalties on a new well, for example, or where there's a title issue and they've gotten a title opinion and their title attorney has recommended that they have all the affected parties sign a stipulation of interest and cross-conveyance. And, you may wonder, well, why are they sending me this document? So we'll break that down for you. So if you do find yourself in that situation, that you know what kind of questions to ask, what the implications are potentially for signing these documents, and then, the pros and cons, right? There's always trade-offs. There's other options potentially that may or may not make sense depending on the situation. But before we dive into that, let's just maybe talk with a scenario here. So let's say that we inherited minerals from our grandmother. And back in a 1950s deed, there's ambiguous language that puts question on exactly what was conveyed and what was owned. And one of the things that may have come up later down the road, typically this is a situation where you're talking a couple generations down the road. The predecessors of interest have passed many years ago. Maybe probate wasn't filed or there was an issue with that in one of those instruments. And we need to clear up title so that we can receive royalties. So in this situation, let's say I got a call from a landman with the oil and gas company and, we signed a lease, we've done all those things. And now they're like, okay, well, we got down to the final title opinion and this is what our title attorney is recommending. There's issues with the title in your minerals and we need to clear it up so we can pay you royalties. And the alternative in that situation is often that they'll place your interests in suspense until you clear up title, until they know for sure that they're paying the right people. So oil and gas companies are pretty risk averse, particularly when it comes to paying mineral interest owners. So they want to be pretty darn sure that they're paying the right people. Otherwise, they're on the hook for, making the rightful owners whole down the road. And that's just a big headache and a liability. So that is one scenario that we'll talk about, and we could dive into that, into why you may or may not want to sign that stipulation of interest. But in the context of minerals and royalties, a stipulation of interest is basically a condition that's saying, okay, this is what we're setting out to do here. This is the goal of this document. And then this cross-conveyance concept, that's basically where you're conveying or transferring ownership between the different parties involved in that instrument. And so just an example, a conveyance document is a deed. That's one type of conveyance. It could be a personal representative's deed that you go through that process when somebody passes away and they settle their estate, then, it goes to their heirs. Or it could be that you sold your house and you conveyed that property to the buyer. So the concept of conveyance is important to understand with minerals and royalties, is because it's when you're transferring ownership or you're exchanging ownership in this context. So in the case of a stipulation of interest, let's say there was a title issue, you have somebody that passed away and you have to go through and either open probate and go through that whole hassle and expense, or another way that an operator might accept and, help you clear up title is to draft a stipulation of interest in cross-conveyance that all of the affected parties have to sign, that says, yeah, we all agree, whatever is in the past is in the past. Going forward, this is what we all own. And it'll typically specify, exactly what percentage in that mineral tract, each person or each party owns. And, going forward at least, and you're, by signing that, agreeing that you're transferring, or receiving any ownership to meet or to match that decimal or fraction that's specified or stipulated in that document. And so basically that concept of cross-conveyance is that party A conveys something to party B, and then party B conveys something to party A. And the result is that you have a very specifically defined ownership that benefits everyone involved, hopefully. And really the ultimate goal is you're consolidating those messy interests, like Justin mentioned, that may have been fractionated and gotten smaller and smaller, and it gets more confusing and harder to interpret each of those deeds, particularly if there's ambiguous language. And, by following what should have happened, and okay, this is what, we need to have in writing that says that everybody that's the rightful heir, they got their fair share. Here's what that actually equals, because right now, if you read the deed, it's not clear. And so oftentimes you'll see those married together. The instrument that'll be filed or that you'll be asked to sign is called a stipulation of interest in cross-conveyance. Justin, you want to talk about your experience with these and kind of when you've been asked to deal with those?
Yeah, I think, Matt, we see a lot nowadays that people do a quitclaim deed into either the estate or maybe into a trust. And a quitclaim deed really isn't specifying any kind of ownership. It's saying whatever I do own. And so in my scenario, typically when those quitclaim deeds were used, later a situation comes up, they want to kind of re-specify exactly what the ownership was. And the easiest mechanism is to get all the parties to agree and to sign a document kind of as a benchmark going forward that, all involved parties agreed on this ownership for each, and they use that to protect themselves and you.
Yeah, that's exactly right. And so what that means is the operator can then pay in accordance with that stipulation of interest and cross-conveyance and have a safe feeling that they're paying everybody the correct amount based on everybody agreeing and signing that document and saying, yes, we agree that that's what we own in that particular tract. And then going forward, that's, what we'll receive in terms of our interest. Now, not to say that there can't be subsequent issues that arise. So this, in a moment in time, it clears up title to those minerals. But, if you don't do a good job of drafting subsequent deeds and there's, issues with title in the future that, could be reason that you need to do it again. Your heirs might need to go through that process again or go through, the process of filing a corrective deed if there was an issue with a past deed. But in any way, the benefit of these is it's typically a very simple and straightforward process, right? You're just having to go to execute the deed in front of a notary and then have them notarize it. All of the interested parties or affected parties have to do that, send that document to the operator, they'll record it, and then everybody's happy and you'll get your division order, you'll get your royalty checks, and then, it's happy days. The alternative is if you disagree with that stipulation of interest in cross-conveyance, you will need to go through an alternative process to clear up title, because the reason that instrument is used is because there's a title issue. If you think that, that stipulation of interest is wrong and you should have more than that, you would need to go and state your case in front of the courts, basically, to get that cleared up. And that would be a quiet title suit typically, or, another legal proceeding, basically, that you'd have to get an attorney and pay to go through and get that adjudicated and have the courts determine that whatever that amount is, that's correct if you feel like the stipulation of interest doesn't correctly give you the interest that you think you should own. So there's a trade-off there. And most of the time it's better and cheaper to sign the stipulation of interest, particularly because the reason for that request to sign it is because they've done, the operator's gotten a title opinion, which is a very comprehensive review of title by an attorney that will dictate what the issues are and what needs to be cleared up. And so there's a reason for them doing it. It's not that they just want to do it just because of the insurance policy aspect of it. There's generally a reason. And that said, there are different ways to interpret deeds and leases and things like that. So it's possible that they have a certain interpretation that you may disagree with, and your attorney may interpret it a different way, and you'd have to go let the courts decide if at that point. And typically that would be something to pursue if there was a significant amount of money on the line, whereby signing that stipulation of interest, you're giving up a significant amount of value. Otherwise, it's doesn't really make sense just to do it just for the sake of proving that you're right. Just because you can get 1/100th of more of a net acre. You may have spent tens of thousands of dollars for that additional $100 in royalties you'll receive over the life of all the wells that are drilled. So it's a trade-off, right? And that's like any sort of legal matter. There's always options and different things to consider. As a side note, I will say that one thing that's very interesting, particularly in Texas, where they take a pretty strict view of pooling around what happens when you agree to pool or when tracks are unitized, that pooling process in the context of pooling and unitization of oil and gas, a conveyance of those interests amongst the owners in those tracks results from that pooling process. And so what that means is each of those individual mineral interest owners will own an undivided interest in the entire unit. And that is your proportional share based on your contribution to that unit, the number of, gross acres, and then your net interest in that tract and so forth. And so in Texas, that's why pooling is such an issue, and people have a lot of heartburn when it comes to pooling, is because by pooling, you're actually cross-conveying your interest to the other owners in that unit. And now maybe not permanent, maybe it's while those wells are operating or while that unit's in effect, but it can be for decades or, potentially a century where that's in place. And so there's, in Texas in particular, that pooling is presumed to cause a cross-conveyance of those interests unless your oil and gas lease or other key documents state otherwise. And so that is where it can be helpful to have a very good and robust lease and having an attorney review your lease if you want to make sure that you retain rights related to pooling and cross-conveyance. And so that is just a side note that's interesting if you're a Texas mineral owner to consider. But in terms of this stipulation of interest and cross-conveyance, it's more to clear up title issues, and that's when you would encounter it. But that concept of cross-conveyance is used in other areas.
You said, Matt, and this is something that's also used in the industry. This is a mechanism that operators can use as well to consolidate ownership and properties for their leasehold interest. It also could be used in a situation where maybe there wasn't a probate that occurred for that, but they need to try to kind of clear up what the title would have been from reviewing the documents. I know in those scenarios, Matt, I think it kind of can vary on the situation, whether the stipulation of interest will suffice in that, but I've heard of that being an option for folks. And then, Matt, I've also encountered it when there was an overriding royalty interest that was set to pay back to a certain amount. After that payback had occurred, there was a situation where they wanted us to sign a stipulation of interest just to kind of understand what that new ownership was since that overriding royalty was paid back. That was years ago, if that makes sense.
Yeah, that's a great point. There's all these very nuanced uses, and it could be that there are proactive ways you could use it. And again, this would be getting with your attorney and getting options. But that option or that concept that Justin mentioned at the start of the show was related to the continued fractionalization of these interests. So in other words, as they're passed down from generation to generation, it gets split into half, and then into another 1/4, and then another eighth or whatever. And so then by the time that you get it, you have like 1/32 of that tract, and it becomes very small. And actually over time, as these interests get smaller and smaller, the expense for managing these properties and for properly conveying these through probate and things like that may actually exceed the value that's there for the minerals. And so it's a good idea if you can somehow keep them whole, whether that's through, like we've talked about in the past, an LLC or a trust or something like that. But other options is if you have multiple tracts and maybe they're in one kind of general area and everybody, siblings, cousins, everybody says, okay, hey, we want to keep these whole, but, let's just separate these out and we'll combine our, undivided interest into larger blocks and then cross-convey these interests to each other so we're all equal and made whole at the end of the day. So that could be a way that you could clarify ownership of those inherited tracts. And so instead of owning tiny fractions of multiple tracts, maybe you own a larger interest in fewer tracts. And so that could be something that's a possibility that, when you have that undivided interest, you can do whatever you want with it, right? You could sell it and you can sort of horse trade with your family members if everybody's on the same page and wants to do that. That could be one potential use case. But again, this is coming from a layperson's point of view. Definitely get help from an attorney if you are thinking about different ways to convey minerals, just to make sure you go about it the right way. And obviously this episode shouldn't be construed as legal advice. It's just for informational purposes only. But I think in my mind, Justin, I think there's sort of key uses. And do you want to talk through kind of at headline level what those common uses or reasons for that, and just to kind of summarize, and then we'll wrap this up.
Matt, there are some really common places, and I think when you inherit minerals is probably the most common. There's been a inheritance that's happened. The next generation receives those minerals, and there's a reason either from the estate or from previous estates that they want to clear this up. Again, maybe it's a situation where there was an overriding royalty carved out or something else carved out that no longer is. In lease negotiations, this could be a situation where they're looking at that work, they're looking at what curative work may be required because they're getting ready to pay folks, and that's a time that often comes up. And then when selling your minerals, so if you're looking at selling your minerals and it's a significant size, then it may absolutely be something where the buyer is taking on a risk. And hopefully a known risk by them into what the title risk is. And there may absolutely be a reason that they want to go ahead and do a stipulation of interest to protect what it is that they're buying from you. And maybe the interest is small enough where they're willing to take that risk, but that is a risk that both the operators and somebody buying your minerals is kind of evaluating.
That's a great point. And another option, if it's a really significant lease, they might need you to sign that before you lease and before they pay you the lease bonus. Wherever it is in that life cycle, it's ultimately, going to be trying to clear up title. So that's resolving title defects is, I would say, the primary use of these types of instruments. And then again, simplifying ownership. If you had very small fractions and you wanted to, horse trade amongst family members to have each person have a little bit more of fewer tracks rather than a very small interest. And then again, it's, that marketable title concept that Justin mentioned. If whether it's you're looking to sell, whatever the situation, it is a way to create clean marketable title that helps with you able to market that, to sell it or whatever, or to receive royalties, which ultimately that's what the operator is wanting to see, is that you have marketable title. You're the rightful heir. They're paying the right person, like we talked about before. And then, again, the reason for this is whether it's through an ambiguous clause or language in a deed or a lease, or if there's, minerals that weren't properly distributed through probate, or that there was, a question about, a half brother or something, or, there's all these funny family, stories, history that kind of pops up when it comes to property and when there's valuable property on the line. And, obviously you can go through and get a quiet title suit to clear that up and to just confirm that you own what you say you own, or you can get a stipulation of interest and get everybody to sign it and agree that, yeah, this is what we are agreeing to as far as who owns what. But ultimately at the end of the day, there's pros and cons of this. Generally speaking, you're usually better off to just go ahead and sign it, if it's accurate, obviously, but generally if you don't know whether it's right or wrong, there's a level of trust you're placing in the title opinion and the interpretation of that title opinion by signing that. But then on the other hand, the alternative is that if you go and fight it or go an alternative route, you need to have financial justification for that to really make sense. So it has to be, in my mind, a significant interest to where the amount that you're going to spend on legal fees to get it cleared up through a quiet title suit or determination of heirship or some other proceeding or reopening probate, and the tens of thousands of dollars potentially that's going to entail is going to be far outweighed by the additional value you would get by hopefully an additional interest or that increased interest. In many cases, it's likely that that you end up in the same place that you started with that stipulation of interest by going through that whole legal proceeding, and you just ended up spending tens of thousands of dollars on attorney's fees, and you just have the same amount that you had to begin with based on that stipulation of interest. Obviously, it just depends on your very fact specific situation, and obviously we're talking in generalities here, so get help from a qualified attorney if you have questions about stipulations of interest before signing them. That's something to take into account. And obviously, like we always say, before you sign any sort of legal document, it's a good idea to have an attorney review it. So, Justin, any final thoughts before we wrap this up?
I think it's just really important to talk with an attorney. If there are other options, they're going to want to look at it and kind of coach you on how those might play out, what the options would be. And like you said, Matt, they're so specific to your individual scenario. It really requires them to take a look at everything and get an understanding so that they can advise you. And as much as the cross-conveyances help and they're practiced a lot, they can also create problems if not done correctly. So really should be done by a qualified person with the proper research done.
Yeah, absolutely. And you can ask if there's a question and you want to have your attorney review that title opinion, or at least the redacted portion covering your interest, then ask for that from the operator. So that's usually when you'll get this type of a document, is when there's a title issue. Well, your first response should be, no matter what, is to say, well, yeah, can you share with me the redacted portion of that title opinion related to my interest so I can understand more where this is coming from. And you'll see in there the title opinions or the title attorney's recommendation, and it'll be that they get a stipulation of interest and cross-conveyance from the affected parties and what the issue is. And by understanding that, you can help make an informed decision as to whether or not you want to sign it. But if you have questions, need help from an attorney, you don't have a good oil and gas attorney, highly recommend you joining NARO, the National Association of Royalty Owners. We'll put a coupon code in the show notes that you can use to get $25 off your first year's membership as an introductory member. And with NARO, they have a supporters directory. So it's all the companies that have supported NARO. You can see a list of attorneys and engineers, landmen, et cetera, that are aligned with NARO's values and mission. So if you need help and need an attorney recommendation, definitely check NARO out and go to that supporter directory to find out more. So again, we'll put some links to some useful articles in the show notes. Hopefully this is helpful if you're dealing with the stipulation of interest and cross-conveyance, and we'll talk to you in the next episode. Thanks, Justin.
Thanks, Matt.
Thanks so much for listening to the Mineral Rights Podcast with your host, Matt Sands. Don't forget to subscribe and share at mineralrightspodcast.com. The Mineral Rights Podcast should not be construed as investment, legal, or tax advice. All information is believed to be from reliable sources. However, we make no representation as to its completeness or accuracy.